Yet another Act 10 court ruling will explain what's in and what's out.
A federal appeals court says Wisconsin's Act 10 is constitutional. Good evening. I'm Eric Franke.
And I'm Susan Simon. Act 10 is the governor's law stripping most public workers of nearly all of their collective bargaining rights. The ruling this afternoon overturns an earlier decision blocking part of the law. Political reporter Jessica Arp is here now to explain all this, Jess.
Well, this is one of the many cases, of course, regarding Act 10. Today's decision says the entire law is constitutional, while other courts have found the reverse. But some say this decision could affect other court cases still in the works.
Well, it's a long-awaited ruling, I think, for all of us. It's much anticipated.
Attorney General J.B. Van Hollen is declaring victory in federal court after the 7th Circuit Court of Appeals says Act 10 is fully constitutional.
And they found that, the other side could make all sorts of arguments of why maybe the state had improper motives. But the bottom line is the motives the state set forth to save money, to protect the public, to make sure we don't have uprisings over Act 10 that got in the way of the public safety system, that those were all very rational basis that justified the implementation of Act 10 the way it was.
The lower court decision originally said requiring votes to remain a union and prohibiting union due deductions were unconstitutional because they violated free speech and exempted public safety unions, some of which had endorsed the governor. In the ruling today, the court found that while Act 10 diminished the union's ability to fund its speech, the obstacle to free speech was the cost, which the state had not created. It also found that distinguishing between public safety unions and general unions may have been a poor choice, but not unconstitutional. In a statement, WEAC President Mary Bell, whose union brought the suit, said educators were extremely disappointed and it marked a setback, but members would not stop trying to restore their rights. There are still other chances, including one Dane County case where a judge has blocked the law on other grounds. But the AG thinks this case may help move that one along.
It's going to be very difficult, I think, for the opponents of the state and the opponents of Act 10 to advance their arguments in light of this particular decision and the way it was written.
Van Hollen says he will file additional information in those cases, including the case in Judge Colas's court that has the entire law held up. An appeals court has yet to make a decision on whether to stay the injunction in that case.
And Jess, some folks actually think Act 10 could go all the way to the Supreme Court.
There's, of course, the possibility of that. WEAC would not say today what its plans are for appeal, but Madison Teachers Union Executive Director John Matthews said in a statement today that he thought the case would go to the nation's highest court.
Political reporter Jessica Arp reporting, Jess. Thank you.